I'm sorry. I'm on the record. Okay. All right, good afternoon, everyone. We're back for afternoon, and I'm going to start with first appearance docket. So when I call your name, please step up to the podium. Martini Hanahan. Hanahan Martini. Diane Hanahan Martini.
Here, present judge at Maine, and she is approaching. Come on up, ma'am.
Good afternoon, Ms. Martini. Ma'am, you're before the court for one count of misuse of 911 or emergency system, and two is a misdemeanor capious city ordinance matter. The court does find probable cause.
And speaking of Ms. Heineman, right now I see that her bond on count one is $100. I know on the municipal ordinance is $50. However, in speaking with Ms. Heineman, there's no one that's going to be able to afford her post her monetary bond. She's on a fixed income. She receives Social Security. She is 67 years old, been living in our community since 1989. She lives in Dania with her brother, but unfortunately her brother right now is out of town. And right now, from what she advised me, there's no other person that could go to a bondsman or come here to the jail and post a cash bond, Judge. I'm asking, Judge, for the court to consider releasing her ROR on count one, Judge.
Okay. All right, Ms. Hanahan, I am going to release you ROR. Ma'am, you have to pay attention to the mail so that you know when you have to come back to court, or if you have to come back to court. What about, is she gonna post a bond on the $50? On the KPS?
You also let me know on the number 2.
I believe she's referring to count two, Judge. The 2004.
Okay, I'll RR on everything. Good luck.
Thank you, Judge.
Jaquidra Jones.
Judge, I've been informed she bonded.
Emily Martinez.
Judge, Ms. Martinez is here present.
Ms. Martinez, good afternoon. You're before the court today for one count of possession of cannabis 20 grams or less. And the court does find probable cause. What is
Judge, in speaking of Ms. Martinez, I see the cannabis offense carries a $100 bond. I don't know if the state would object as far as an ROR on Ms. Martinez's behalf on the cannabis offense.
It's fine.
I'll RR Ms. Martinez. Good luck, ma'am. Kimberly Osborne.
Ms. Osborne is approaching, Judge. She's here at Maine.
Ms. Osborne, good afternoon. Ma'am, you're before the court for one count of grand theft. The court does find probable cause. Anyone wish to be heard as to the bond?
Judge, I do. Ms. Osborne, she's a mother of 3 kids right now. She's not working. She lives locally here in our community in Deerfield Beach. She's been here her whole entire life. She's 37 years old. I do understand. It advised me that she has priors, Judge. So I'm not going to be asking for an ROR on this felony offense. What I'm going to be asking for, so she could be out, Judge, to consider releasing her on pretrial release.
I will release Ms. Osborne on standard pretrial release. Ma'am, ma'am, you need to report to the pretrial office within 24 hours of your release, and failure to do so could lead to your arrest.
Good luck, man. Make sure there's the
Good luck, ma'am. Letitia Washington.
Okay?
Letitia Nanette Washington.
Washington.
Miss Washington, good afternoon, ma'am. You're before the court for one count of grand theft, 2 grand theft auto, 3 and 4 is possessing, passing forged or falsely embossed altered credit card. 2 counts of that. The court does find probable cause, ma'am.
Judge, I see probable cause for one count of grand theft, or attempted grand theft, I guess. I don't see a value amount mentioned as far as the $20,000 to $100,000 is concerned in the probable cause affidavit itself. It looks like she attempted to rent a vehicle using a false credit card, and she had 2 Visa cards in her possession that did not belong to her. But so I see count 3, I see count 4, and I see an attempt on count 2, and I don't see probable cause on count 1.
First, the easy part. There is no attempted theft. Theft includes attempt. Endeavoring to steal is theft. As far as count 1, Your Honor, I imagine what the officer is referring to is the value of a Range Rover. Now, while it doesn't mention a specific value, and I would agree to that it should be considered a grand theft 3rd degree at this time, I would ask the court to take into consideration when setting a bond that Ms. Washington wasn't looking to fraudulently rent a Honda Civic or something. It was a luxury vehicle with a certain amount of, I would say, great value. She, well, I'll wait till the court makes a PC determination.
Well, the value of the reserved Range Rover, or the value of the rental, is $791.75. That's in there.
And I think what he was referring
Yeah,
to.
I'm sorry, go
I think
ahead.
what he was referring, what the officer's intent was, the total value of a Range Rover, which isn't listed, and that's why I have no objection to the court making a finding of grand theft 3rd degree for the $791, the value of the actual rental.
Okay. Then that's fine. I'll do that. I'll find out probable causes for the grand theft.
She does.
As to bond?
Let's see. Your Honor, she, in 2016 out of Palm Beach, she was convicted of grand theft auto, grand theft, let's see if there's anything else. Nothing, no other priors, just obviously renewing. When setting the bond on count 1, obviously the type of property I think should be taken into consideration. Nothing further.
Judge, if I could be heard, first in speaking, Ms. Washington, I did advise her today is not her trial date, but she is disputing some of these important allegations. So I did tell her that that will be determined on the later day, so she is looking forward to having her day in court. Having said that, Judge, she is a single mother. She resides in Hallandale, and she's working, Judge. Right now, her child is currently being taken care of by the grandmother, Miss Washington's mother. She's asking the court to consider releasing her outright ROR. So that's what we're asking for at this time, Judge, and straight ROR on her behalf.
Well, straight ROR is going to be denied. All right, I will, did you say Ms. Washington was working?
Yes, she is working,
Where-
Judge.
where-
Then, Judge, in the alternative, if the court's not comfortable with the straight ROR, and I understand why, but would Your Honor feel comfortable releasing her on standard pretrial release? She will be coming back to court, because she is looking forward to contesting some of these allegations. So Judge would be asking for the court at this time to consider standard pretrial release.
And, Your Honor, whatever the court deems appropriate. But Mr. Romero keeps bringing up she's looking forward to refuting the charges. The court's familiar with the allegations, and the allegations is pretty strong evidence against her. Credit cards in her name that were deemed to be fraudulent, that were found in her, on her person, in her purse, that she was trying to fraudulently rent this rental car with.
All right, as to count one, I'm going to impose a bond of $2,500. And counts 2, 3, and 4, I do a finding for grand theft. It's gonna be $1,000. And that's also going to be in addition to standard pretrial release. All right, good luck, ma'am. Latrina Thomas. Good afternoon, ma'am.
Hello.
Ms. Thomas, you're before the court today for one count of burglary on occupied structure unarmed and 2 grand theft. Well, did we make on the one before, Madam Clerk? Did we make the change? Yeah. Okay, thank you. Ms. Thomas, you're before the court for burglary of an unoccupied structure and 2 is grand theft. The court does find probable cause. Okay, the parties wish to be heard as to bond? Ma'am?
Yes.
Can you tell, what's your name?
My name is Sonia Henderson.
Yes.
I'm her twin sister's, but her mom died when she was young. So I'm her, legal mom. Was raised with me.
Okay.
And she works and everything like that. And happened so, it was something that, caught up in the wrong way. She was working there. So I don't know what's the problem. That's it, what I mean? But I would wish that you can give her a bond on that first one that they said burglary, where they didn't have no bond on it.
Right.
For her.
Right, so that's why we're here today, for me to set the bond.
Okay, thank you very much.
Okay.
Thank you.
Oh, I'm sorry, I didn't mean to.
No, she was, you were finished.
Okay, thank you.
Yes. You can go ahead, Mr. Romero.
Judge, my understanding is, in speaking with Ms. Thomas, she basically has a clean record. She's a registered voter here in our community. She's been here her whole entire life. She is 37 years old. She has a new job, Judge, where she's working at a place called Life Storage, in which she's making about $12 an hour. She lives here locally in Davie. Judge, if the state can confirm that, in fact, that she has no prior convictions, she has a clean record, I'm going to be asking the court to consider an ROR on her behalf. If the court's not comfortable with the straight ROR, then what I would be asking, Judge, considering her strong ties to community, her lack of financial resources, I'm going to be asking the court to impose a $1,000 bond on the 3rd-degree felony on count 1, along with the second. That would be $2,000 total that we would be requesting if the court's not comfortable with the straight RORs.
I was going to be requesting a $2,500 bond on count 1. I don't think the fact that she's gotten a new job is really that much of a mitigating factor, considering this burglary was allegedly against her former employer. She's caught on surveillance, breaking into the business without permission and stealing over $1,500 worth of cash that apparently has not, or was not, and has not been recovered.
Judge, the mitigating circumstances is basically she has a clean record. She's presumed innocent. Judge, I'm going to be asking at this time, if, like I said, I guess the state's not comfortable with having her release ROR. So, Judge, I'm asking then the court to consider $1,000 bond on count 1, $1,000 bond 2 on count.
Okay, Ms. Thomas, the court does find probable cause, and I am going to impose a bond of $1,000 on count one, and the bond of $1,000 on count two. Good luck. Thank you, folks. Merlene Etienne.
She's approaching, Judge.
Ma'am, you're before the court today for one count of grand theft and two illegal use of credit card, and the court does find probable cause.
This is the same type of situation, Your Honor. I understand, and I imagine Mr. Reedy was going to argue that it's doesn't mention the value of the vehicle on count one. So if the court wants to find probable cause for grand theft auto or grand theft third degree, I'm fine with either one.
That would be my argument, and I think that there is probable cause to support that.
That being said, again, there's an allegation Ms. Etienne is committing fraud to steal a luxury vehicle, this time a Porsche. So I do have a concern. I would note she has 7 prior felony convictions, 4 prior misdemeanor convictions, it appears she does have theft-related priors. Your Honor set Ms. Washington's bond on the similar grand theft at $2,500. I would ask the court to set the same bond on this charge.
Judge, I believe the court's found probable cause on a third-degree grand theft offense on count one. I believe the standard bond is $1,000. Having said that, I spoke with Ms. Etienne. She can't even come up with those $2,000. Now, she does have a record, I believe, and I didn't hear what Mr. Lender said as far as the dates, but in speaking with Ms. Etienne, she believes they're dated a couple of years ago. She's 34 years old, been living here her whole entire life. At this time, she has 2 jobs, Judge. She's working for a company called Neva and Judy, which is she does billing and coding, and she's been working there since 2015. It's a part-time job, making about $10 an hour. And then she works for another company called Aleman Air Conditioning, and she's been there 5 years, working part-time, about $10 an hour. She lives in Miami with her aunt. That's that she could help post her monetary bond. Her aunt is a housekeeper, and she does not believe, after paying rent, that they have any sort of money to monetary bond, and that's why Ms. Etienne is basically forced in a position just to ask for standard release on her behalf, Judge, and that's what we're asking on this non-violent offense.
I'm going to deny us the pretrial release. The bond on count one will be $2,500, and the bond on count two will be $1,000. Good luck. Warren Pullis.
Judge, I've been informed Ms. Pullis bonded.
Okay.
Mr. Pullis. It's Mr. Pullis.
Medan Gonzalez.
He's here at Main.
Gonzalez, Luis Gonzalez Medan.
Gonzalez.
Mr. Gonzalez.
Sir, you're before the court this afternoon for one count of petty theft. There's also an out-of-county misdemeanor hold, which is not for magistrate. The bond on the petty theft is $25. I'm going to leave. I do find probable cause, and I am going to just leave everything in place. Good luck, sir.
Judge, and speaking of Mr. Gonzalez, he did want me to ask the court if the court would consider resolving count one, the misdemeanor offense.
All right. Does Mr. I don't know the status of the other case. If it's a driving while license. Does the state have an offer for Mr. Gonzalez, Madame?
On count one, if he wants to resolve, one moment, Your Honor. Unfortunately, I can't. It looks like there's going to be a restitution involved in this matter. It's a yellow cab where the fare wasn't cleared.
All right.
I understand.
Okay, good luck, sir. Jason Perez.
Mr. Perez is here present. Jason Perez, want him? He's approaching, Judge, and he declined the services of public defender.
Good afternoon, Mr. Perez.
How are you?
I am fine. Sir, do you understand that you are entitled to an attorney at this stage of the proceedings?
I'm aware.
And is it true that you do not wish to have the attorney from the public defender's office represent you at this time?
Yeah, I mean, I would like, can they work with me now and then switch to another attorney later on?
You can, it's your decision, sir.
The whole thing is that I just haven't been able to reach out to my attorney yet. So I guess I would like to have public defender help me now, and then I'd like to switch to one of my attorneys, if that's okay.
That's your decision to make, sir. You just, I guess, need to let the public defender's office know if you need them to speak with you at this time.
So what would you like me to do, ma'am?
No, not what I want you to do. I'm telling you that you have the opportunity of having an attorney from the public defender's office represent you. Or if you choose not to, that's your decision. I'm not telling you what to do. I'm just asking you if you're sure that, you want to proceed at this time on your own.
Okay, so what I would prefer is to have the public defender help me now, but then I'm going to be switching to one of my regular attorneys. Is that okay?
And what I'm telling you is that that's your decision. I can't tell you yes or no. It's your decision.
That's what I would like to do.
Okay. Judge, if we could put him on brief recall then?
Sure. Corey Stewart.
He's coming up, Judge.
Good afternoon, Judge.
Good afternoon, Mr. Stewart. You're before the court for one count of trafficking in LSD, distribution or delivering LSD, third distribution or delivering LSD, 4 out-of-county hold on a misdemeanor, 5 is a felony capias, and 6 is a traffic capias. And the court does find probable cause. And my notes indicate that you should be in your felony division tomorrow at 8:30. So at this time, I am going to leave all the bonds in place. And you will see your felony judge shortly. Good luck, sir. Radcliffe Barnett.
Mr. Barnett is here present, Judge Aman. He's approaching.
Mr. Barnett, you're before the court today for a grand theft, and I do find probable cause. Does the parties wish to be heard as to bond?
Yes, Judge. Mr. Barnett is going to be requesting pre-trial release. Before I proceed, I'll see if the state has an objection.
One moment, Judge. Yes, based on his criminal history.
Judge, right now, Mr. Barnett is not employed. He's currently actively looking for work, from what he told me. He's 42. He's been here his whole entire life. He lives in Fort Lauderdale with his mother. Now, his mother is working. She's a caretaker, and she's right now helping him as far as paying all the expenses associated with their apartment. But unfortunately, from what he advised me, he does not think that she can afford anything. And that's why we're going to be asking on this nonviolent offense for the court to consider releasing him on pretrial release.
Your Honor, Mr. Barnett just got out of state prison December 22nd of last year. That was after being sentenced to 14 months on 2 separate 2017 felonies, one for grand theft, the other for possession of PVP and unlawful use of false name ID. 2015, he had another possession of PvP. He violated probation, was sentenced to 14 months. 2014, resisting without violence. 2008, possession of firearm by convicted felon, carry and conceal firearm. 2001, possession of cocaine. 2000, possession of cocaine with intent. Multiple drug priors earlier than that, Your Honor.
Okay. Pretrial release is going to be denied at this time. Sir, your bond is $1,000. Good luck. There is on page 9, Hunter Little. Is there someone in the courtroom for Mr. Little?
Sir.
Okay.
Judge, I'm going to need an opportunity to speak with Mr. Little.
Okay, then I'll recall it, sir. His attorney needs to speak with him. I was calling because you'd signed in. Good luck. Andres Correa.
Mr. Correa, is he your friend? Come on up, sir.
Yes.
Samuel Hunter?
Hi, Your Honor.
Mr. Correa, you're before the court this afternoon for 3 counts of burglary of an unoccupied conveyance unarmed and 4 resisting officer without violence. The court does find probable cause. What says the parties?
I'll be requesting a $3,500 bond on count 1, $1,500 bonds each on 2 and 3. Not only the allegations, but also Mr. Correa's criminal history. Out of the state of New Hampshire, he was convicted last year of violating a protective order.
Deputy Death. How much?
2014 obstruction.
Sign your name or your name and address.
Assault
Any
and
other pictures of this?
he's convicted of assault and stalking. It was in
Write your
2004.
name and your address.
Criminal trespass 04. Another stalking from 2000 and
You're out.
that was from 04 as well. Theft 04.
Billy Avenue in Hollywood.
Also out of the state of Texas. Trespass, criminal trespass, disorderly conduct, discharging or displaying a firearm. That was from 2016.
4 years.
Right now, I don't know how much they said. They said 1,500, 1,500.
How's your health?
I don't know how much they said on count 1. I gotta ask him.
Okay, so I do find probable cause, and on count 1, the bond is going to be $33,500, and then counts 2 and 3 will be $1,500, and there's $100 on count 4. Good luck, sir.
Judge, did the court say 3,500 on count 1?
Yes.
Judge, in speaking with Mr. Correa, I believe that's $6,600 bond total. He's not going to be able to afford that. He is working. He works at a restaurant as a server. So financially, he can't afford to post a monetary bond. He's living in Miami. He's about $700 per month. It's called. He's residing at the Acceptance House. Now, he does have family that he can reach out to, but he doesn't think they're going to be able to afford that, Judge. I'd ask the court to reconsider and lower his monetary bond, Judge.
At this time, that's going to be denied. Good luck, sir. Jonathan Lewis.
Mr. Lewis is approaching, Judge. He's here at Maine.
Mr. Lewis, you're before the court for possession with intent to sell, manufacture, or deliver cocaine. 2 is a municipal ordinance violation, and 3 is a traffic matter not for magistrate. The court does find probable cause.
Judge, we're going to ask for two requests. One, a phone order so Mr. Lewis can access his phone contacts so he can contact his friends and family to post his monetary bond. And number two, I haven't had an opportunity to review the PC affidavit. Does it indicate anywhere in the PC affidavit that law enforcement confiscated funds from Mr. Lewis?
Yes,
Yes.
$621.
Thank you.
All right, I'll sign the phone order. The bond is $2,500 on count one. And the other matter is a municipal ordinance. I will not impose a bond. Good luck.
So what, my bond, what's?
Yep.
Brooks Edward Burgess. Okay,
Bond, I've been informed, bonded, Judge.
thank you. Sheldon Stephen Mason.
He's approaching.
Mr. Mason, you're before the court today for one count of leaving the scene of a crash involving damage to property, 2, driving while license suspended or revoked, 3, possession of codeine, 4, possession of cannabis, 20 grams or less. Then the court does find probable cause. What does the parties wish to say about bond?
Judge, nothing to add at this time.
Okay. All right, as to count one, I'm going to impose a bond of $500. Count two, $500. Count three is $1,000. And count four, $500. Good luck. I'm sorry?
Judge, he's not.
500, 500, 1,000, 500.
Judge, and speaking Mr. Mason right now, he was barely going to be able to see if his mother can afford $100 bond going through a bondsman. Judge, this is certainly something that's going to be out of his financial possibilities at this time, Judge. He's currently working. He works at a place called Feeding South Florida, where he's been there for about 2 months, making approximately $10 an hour. Now, he does live in Pembroke Pines with his grandmother and his mother. Now, his grandmother's elderly. She gets Social Security, so she can't afford to help post his monetary bond. And Mr. Mason's mother, though, is working. She's a caretaker. He believed that maybe she can come up with $100, and that's why at first I was going to ask you to leave the monetary bond in place. But this is something that, like I said, she cannot. So at this time, I'm going to be asking the court to consider releasing Mr. Mason on pretrial release.
Mr. Mason is out on $3,300 worth of bond from an arrest last month for domestic violence battery, possession of heroin, cocaine, 2 counts of drug paraphernalia, and a capias on a pending DWLS.
That's going to be denied at this time. The bonds are as previously stated. Did I call this one already? Samuel Hunter.
He's here present, Judge Maine.
Mr. Hunter, you're before the court today for one count of neglect child without great bodily harm, and the court does find probable cause. Does the parties wish to be heard?
dropped. Yeah, Your Honor, I'm going to be requesting a $7,500 bond and an order of no victim contact. No possession of any firearms, weapons, or ammunition until further order of the court. I'm very concerned based on these allegations. Thankfully, nobody was hurt. I would also note Mr. Hunter has been arrested on at least 2 occasions for unlawful possession of a firearm, but it does appear that each case was dropped.
Judge, I did advise Mr. Hunter that maybe a possibility that the state would be making that recommendation as far as no contact. Now, I know his son is right now being taken care of by his sister. He's 26 years old at this time. He's not working. He's currently going to school. He goes to Everglades University. He's studying alternative medicine. He just started that, I guess, that trade or that career. He's paying for that through Blade. So he really has no sort of income, Judge. We're going to be asking the court to consider a $1,000 bond on Mr. Hunter's behalf.
Court does find probable cause, and I'm going to impose a bond of $2,000, but that's also going to include a standard pretrial supervision, no contact with the minor in this case, no possession of any firearm, and if Mr. Hunter has any other firearms, he needs to surrender them before release. Good luck, sir. Devin Jackson.
Mr. Jackson is approaching, Judge.
Mr. Jackson, you're before the court today for 1 count of driving while license suspended and 2 unlawful speed, which is not for magistrate. And I do find probable cause, and I'm being told by confinement that your bond has been posted. Good luck, sir.
Good luck, sir.
How about Michael Westover?
Mr. Westover is here, Judge.
Mr. Westover, you're before the court today for escape or attempt to escape. And the court does find probable cause.
Your Honor, this is certainly unusual circumstances. That being said, considering, and I assume Your Honor has a copy of the complaint affidavit even from 1988, considering the allegations that he escaped from DOC custody in Broward County in '88, and considering the nature of the offenses that he is completing his prison sentence on, that being third-degree murder, robbery with a firearm or deadly weapon, and grand theft, I'm asking that the court keep the $5,000 bond in place if he remains in custody. I imagine he's going to be brought, he will need to be brought before Judge Weeks, who is assigned this case for an arraignment.
Judge, the only thing I can say, Judge, he's currently still finishing up serving a sentence. I believe his EOS date is this Sunday. He's been in custody for quite some time, Judge. He's financially indigent. There's no way he's going to be able to afford a $5,000 bond.
All right. The court does find probable cause, and the bond will be $5,000. Good luck. Michael Roberts.
Mr. Roberts, come on up.
Mr. Roberts, you're before the court today for one count of burglary on occupied dwelling unarmed and 2 petty thefts, and the court does find probable cause.
Your Honor, I'm going to be requesting a $10,000 bond, but frankly, either way, I think it's a moot issue. He's here because Judge Lynch signed a transport order, having him brought from DOC custody to Broward. My understanding, if confinement can confirm this, is when he's done, he'll be going back into DOC custody.
Okay. The bond on count 1 is $10,000, and on count 2, it's $100. Good luck. Are we ready with Hunter Little? That's the one, right?
I just right now, I'm gonna speak, it'll take me a minute, Judge.
Okay, go ahead, Mr. Romero. Were we waiting, Jason Perez, what were we doing with him? Were you waiting for? Oh, no, that's okay, well, Mr. Romero's back, sir. I was just trying to figure out why we were waiting for you. Yes.
Judge, we're ready on this gentleman right here.
Okay, Mr. Perez? Sir, you're before the court today for one count of DUI. And the court does find probable cause. Your bond is, Mr. Romero, you wish to be heard in regards to the bond?
No, Judge, he's giving me the phone number of his mother, who I intend on calling right after court so she can post his monetary bond.
All right, your bond is $1,000, sir. Good luck. And then are we ready for Mr. Little?
Yes, we are, Judge.
Sorry about that, buddy.
approaching, Judge.
And so Mr. Little is before the court for aggravated assault with a deadly weapon without intent to kill, both counts. Count 1 and 2 is the same thing. And the court does find probable cause, as the parties wish to be heard as to the bond. Sir, you were here on on Mr. Little's case? I'm sorry?
I just found out about an hour ago about this
Okay.
situation, so I'm his father,
Okay, sir.
so I'm not sure what the protocol is.
Okay. Well, there's an attorney with him over at the main jail who's, I guess he's spoken to, and he's gonna,
We all trust what he's doing.
he's going to speak to me on his behalf. There's also another attorney in the courtroom here is also from the public defender's office. I don't know if you wish to speak with him or if you had already spoken with him.
No, ma'am, I've not spoken to anyone.
All right.
Would I do this
Judge,
after this
may I have
procedure?
1 moment to then speak to my colleague right now, Mr.
Sure.
Reedy? I want to just
Sure,
information
sure,
out.
sure. Sure.
And when they found him, Kiefer, he eventually made contact. 6 cutting instruments.
Whoops. I don't even know the story. I haven't seen him or talked to him or spoken. Stand and wait or sit down? Thank you.
Okay.
Thank you, Judge.
All right. Or did the state go already? I don't know.
No. Your Honor, I'm going to be requesting bonds in the amount of $7,500 per count, pretrial release of the GPS monitor, no victim contact, no return to this business. I don't know what's going on with Mr. Little. I only have what's in front of me. We have the allegations in this case. He was arrested last year in Palm Beach County for battery against a victim over the age of 65. That was dropped. In this instance, he's allegedly not only threatening a couple employees of an ice cream store, he goes behind the counter threatening them with a sharp object in his possession. And then when he's ultimately apprehended, there's a total of 6 sharp objects or cutting instruments found in his possession.
In speaking with Mr. Little's father, Your Honor, my understanding is that there's not a lot of money here. The father indicated he could probably come up with about $500. So we're going to be asking the court for a bond of $2,500 on each count.
And Judge, just to give you a little background on Mr. Little, as the state pointed out, he does have a clean record. He's a registered voter. He's basically been in South Florida his whole entire life, except for 2 years in 2015, 2016, in which he attended Florida State University. At this time, he's still in school. He's at Palm Beach State studying economics, and he's going to school, taking about 12 credits this semester. He pays for his schooling with both financial aid and scholarship. So, Judge, in speaking with Mr. Little, there is not much financial resources, and he's going to be relying on his father, and he appreciates his father being here for support, but he's going to be relying on his father to help post his monetary bond. So I'm going to be echoing my colleague's request. I'm going to be asking $2,500 bond on count 1, $2,500 bond on count 2. We have no objection with the state requesting as far as no return to the premises, no sort of, possession of any weapons. Judge, Mr. Little can't afford anything much than the $2,500 on each count.
Okay. And sir, did you wish to say anything?
I'm not really sure what to say. Right
Okay.
now.
You don't have to say anything.
Yeah, I'm just
Okay.
I'm a little in shock by what I'm hearing.
Okay.
By, I guess, the county attorneys over here. I'm just perplexed by what I'm hearing. So yeah, if we can proceed however we need to proceed. I don't know if there's going to be a hearing after this. If
So
there's a
this
bail
is-
post, I'm not sure what the procedure.
So let me explain. So
Thank
this is his first appearance. Everyone who is arrested within 24 hours, it is required by law that they be brought before a magistrate court, which is where he is now. And my job today is to set a bond or some release conditions. After that, his case will be assigned to a regular division where he will have another judge who will be the judge who will hear his case until the completion of the case. So that's what's going on here today. So my job today is I'm going to determine probable cause to detain him. And once that's done, now I have to make a determination as to release conditions. So you'll be able to speak with his attorneys if he continues to be represented by the attorneys from the public defender's office.
That would be another day.
You'll
Or
have
today I
another
could
day,
speak.
another time. They can tell you when to speak with them to
Can
see
I
how to
speak with them
proceed
today?
further. Well, Mr. Reed is here. You
Oh,
can ask
okay.
him.
Would I do it now
Yes.
or?
Well, he'll tell you. 'Cause
Okay.
He'll tell you when.
I would like to do that if I could
Okay.
for a few minutes.
So I don't.
I think there's more here than there's more. I'm seeing more here than meets the eye.
Well.
So I'm just concerned about.
That's quite possible, but for
Yeah.
today, I have to rely on what's before
Thank you.
me.
Yes, ma'am.
So I do find probable cause, and what I will do is I will impose a bond of. Does he live with you?
No, he has his own place that he gets aid and pays for, so he would be, back in his own apartment.
All right. I'm going to impose bonds of $2,500 on each count, but I'm also going to add a GPS.
What is that?
It's
Like
an
an ankle
monitor.
bracelet?
Yes.
That he has to wear?
Yes. And so he has to
Okay,
report
thank
to
you.
a pretrial release. He'll speak with him.
Does he have does he have to stay at his house, or can he go to school, or does he have to stay home? Or?
He he can go out there, but they'll give him instructions as to
How it functions?
what he needs to be doing, okay?
Yes, ma'am.
All right,
Okay.
so Mr. Little, are you also Little?
Yes.
Okay, so
I am.
when I say Mr. Little, I'm speaking
Yes,
to
ma'am.
Mr. Little. Do you understand everything that I've just said, sir?
Yes.
Okay, all right, good luck, sir, good luck. Good luck, Mr. Little.
Thank you, ma'am.
The court order, just no return to that
Um,
establishment.
wait, Mr. Little, don't go anywhere.
Yes, ma'am.
I've said a lot, and there's just a little bit more that I have to say.
Yes, ma'am.
As to he cannot have any contact with Quanisha Wallace or Cheyenne Williams. Those are the two alleged victims in this matter, and no return to Carvel Ice Cream Store. He cannot
Okay,
go
yeah,
back to the Carvel
I
Ice
have
Cream
no
Store.
idea where it is or who they are, but,
3600 West Commercial Boulevard in Lauderdale Lakes.
yes, ma'am.
And
Okay.
okay, good luck, sir.
Thank you, ma'am.
You're welcome. All right, let's go to the felony docket. And we have James Kelly. Mr. Kelly bonded. Holly Mendoza.
North Broward.
Good afternoon, Your Honor.
Good afternoon, Ms. Mendoza. State, what's the status of Ms. Mendoza? She was arrested on January 5.
Yes, ma'am.
Can't believe we're in a second month.
Yes, Your Honor, the state filed some of the charges. We did not file the possession of fentanyl and cocaine. We did file dealing in stolen property, grand theft, and child neglect.
Okay, so the information has been filed, ma'am. You were brought today for a 30-day motion for ROR, so they filed the information. Good luck, ma'am.
Okay, thank you.
Good luck, Holly.
Thank you.
Eddie Ribolo.
Ryan?
Paul Ryan.
Yes, ma'am.
Paul Ryan, Your Honor.
Mr. Ribolo.
Yes, ma'am. Good afternoon.
Good afternoon. You're here for a 30-day motion for release. You were arrested on January 5. State?
State has filed an information, Judge.
Okay, Mr. Ribolo, you were brought to see if the information has been filed, and it has. So there's nothing else for us to do today. Good luck, sir.
Thank you.
Keith Vento.
He's here, President Judge of Maine.
Mr. Vento, what's going on with Mr. Vento?
We have not filed an information in this case. He's entitled to an ROR on these charges, Judge.
All right.
One moment, Judge, one moment. I just want to make sure that Mr. Vento wants me to proceed in this fashion. Judge, at this time, in speaking with Mr. Vento, we are withdrawing our motion. My understanding is he has, from what Mr. Vento advised me, he has a no bond hold on a DUI offense. He wants to get all his credit. So at this time, he's not wanting to go forward on that motion.
So he doesn't want to be ROR'd.
Well, could I get pre-trial on my other case?
No, I don't know what other case you have. But
I have a no bond hold on a DUI.
No. That's not before the court today.
It's a court order, no bond.
Okay,
There's
so
no revocation.
Right. No. So, okay, thank you. He doesn't want anything to happen today. Patrinda Duversi.
Paul Ryan, Your Honor.
Hi, Judge.
Hi, Ms. Duversi. She was arrested on February 4th. So she's here for a second look.
Yes, ma'am.
All right. Yes. What was the bond on Miss Diversey?
It's $1,000 on the possession of cocaine. She does have a history. Her history is mostly drug-related. PVP and methamphetamine 2016, PVP 2015, PVP 2015, controlled substance 2015. Just checking real quick to see if there's ever been, from what I can tell, any violations of pretrial.
Yeah, and while you're doing that, I'd advise the court, I'm looking at the probable cause affidavit right now, and this looks like it is a possession of paraphernalia charge. The item in question was a crack cocaine pipe. The odds are very good that the state will not file this as a felony, but will file it as a possession of drug paraphernalia charge, which would greatly affect Ms. Diversey's current bond conditions.
Yeah, I think the issue is looking through here. It seems like every time she's been arrested, it's either been on a capias for a failure to appear in court, or a violation of pretrial, or she had a pending case and then got her bond revoked. Just checking. Last time she was placed on pretrial, it was a 2015 drug case at a drug court, and upon her release, she never reported to pretrial.
And that was what, 2015?
That was 2015.
Well, it's
But since then, it's been a lot of failures to appear.
Mr. Diversey, you have to come to court.
Yes, sir. Yes, sir. I was scared of pretrial. I was so scared. I'm bipolar and schizophrenia. I get a check I get Social Security benefits every month. I got so scared. I was outside the pretrial place. My ride said they was leaving me. They didn't want to come in the building with me. I left with my ride.
Where do you stay?
They were my grandparents in 610 East Melrose Circle. They don't speak English. I'm Haitian, sir.
How long have you been living there?
I've been living there on and off. I was in the divorce. I'm in the middle of getting a divorce with my husband right now. He had left me staying in an apartment on 2nd Avenue. It's on and off where I go stay with my parents. Well, I'm not, I'm really on my own.
Ms. Diversey, you don't have to put your mouth down to the mic. We can hear you if you just
Yes,
talk.
Judge.
Okay. All right. Where do you say what do you say is your permanent address?
610 East Melrose Circle.
And who lives there?
My grandmother, Camila Diversey.
All right, Mr. Diversey, I am going to put you on pretrial release. There is going to be random drug testing that's going to be imposed. Ma'am, there's nothing else I can do if you don't show up for pretrial release. You will be arrested.
Yes, ma'am.
Okay, good luck.
Will I be going home today?
If there's nothing, I don't know what else.
I don't see anything else holding her, so yes, she should be. But you got to come back to court.
Within 24 hours of your release, you must go to pretrial release.
I'm already kind of like got marijuana in my system, Judge. Well, Judge, Jackie Powell.
You're gonna be on random drug testing, so.
They're not going to violate her, Your Honor.
Not when you get out, right?
Yes, ma'am.
Okay.
Good luck.
Gina Luzzi. Who does?
Hold on, Your Honor.
Diversey?
That's the other witness before, okay?
Gina Luzzi also.
Lizzie.
Miss Luzzi, good afternoon.
Good afternoon.
All right, Miss Luzzi is on the misdemeanor docket
And the felony docket. I
and
think she
the
has a
felony
municipal
docket.
ordinance.
Yes, I see that. But she's here for a second look. What's going on with Miss Luzzi?
Well, she can't make her bond, Judge.
How much is the bond?
It's $1,000.
And I suspect on the municipal ordinance is what, $25 or
I
something?
think there's no bond on each of them. I mean, like, there's no bond attached.
Right. Oh, okay. All right, Miss Luzzi, where do you live?
Live at 1953 Pierce Street.
Who lives there with you?
I live in a group home.
Okay. All right. I will ROR Miss Luzzi. Ma'am, you've got to pay attention to the mail to make sure that you know when you have to come back to court. Because if you fail to come to court, there's going to be a capias issued for your arrest. Do you understand that?
Thank you.
All right, good luck, ma'am. Alex Picard.
Judge, I believe he was released.
Okay. So, let's see. All right. So then on our misdemeanor docket, we did Miss Luzzi. Major Bird.
Major Bird is here present, Judge, and Maine approaching.
All right. What's going on with Mr. Bird?
Judge, from what I could see here, he initially was being held on a no bond VOP 948 hold. My understanding is his probation was reinstated. The only thing holding him is this misdemeanor cannabis offense. I wanted to see if the state has an objection to an ROR on his cannabis.
No, that's fine. Does he possibly want to resolve it or hear what the state's offer?
That's what I asked him, and he said he wanted an ROR. Okay. I'll ask him again. Let me ask him again.
The offer would be a withholding court cost on the cannabis and paraphernalia. If he wants it. He doesn't have to, obviously.
I know the date. I'll come.
Well, they can't tell you that you're going to get a notice in the mail. Okay?
See, address.
Well,
they don't have my address.
Well, we go ahead and give the clerks your address right now.
All I can tell him, I'm staying in the Hamlet Apartments, and I could give you my mom's number, and she can give you the address. I don't know it myself.
Judge, I gave him, I told him as far as the available options, as far as resolving the case today, and I gave him the state's offer. He wants an ROR because he says he's going to come back to court for it. The only thing I believe that seems to be an issue, I don't know what address the clerk has for him, because my understanding from what he said, he's going to be staying with his mom, and he doesn't have the address of his mother.
Well, he's on probation. Did you say his probation was reinstated?
Yes,
so
he's on probation.
I'll ROR him at this time. Good luck. Frank Kramer.
Conti, Your Honor.
Okay, Mr. Kramer is here. It's not quite 30 days yet, so
It's actually a down file, Your Honor. It's a second look. He completed his sentence on another case, and now he's just being held on this. If he wants to plead it out, let me just make sure that there's no issues with restitution first. If he wants to resolve it, Your Honor, the offer would be an adjudication time served.
Is that what you'd like to do, Mr. Kramer?
Yes.
All right. And we've confirmed this is he's resolved everything else?
Yes, Your Honor. Just he's being held on this case, which was originally a felony, and another misdemeanor case, 19977 MM10A, theft and paraphernalia. BSO Picks indicates his sentence is complete on that case, and now he's just being held on this misdemeanor down file.
Does that sound about right to you, Mr. Kramer?
Yes. Yes. Yes, sir.
All right, Mr. Kramer, please raise your right hand. Do you swear or affirm to tell the truth?
Yes, ma'am.
Okay, you can put your hand down, sir. Do you understand the proceedings that we're in today?
Yes, ma'am.
And do you need more time to speak with your attorney?
No, ma'am.
Is anyone forcing you to resolve this petty theft charge today?
No.
Are you under the influence of alcohol or drugs?
No, ma'am.
Do you understand that if you're not a U.S. citizen, that by taking a plea could subject you to deportation or immigration changes?
Yes.
What plea do you wish to enter, Mr. Kramer?
No contest.
Then I accept your no contest plea, find that it's freely and voluntarily given, sentence you to adjudication and time served on the petty theft. Good luck, sir.
Thank you.
All right. I believe that's it for the afternoon. He's been released. Picard has been released, and all these other ones, Vento and Kelly. Those people were released, so there was nothing. Okay.
Have a lovely evening, everyone. Thank you, Madam Clerk. See you all tomorrow, Judge. Have a great evening.
Mr. Reedy, you sound so much better. Good
Oh,
luck.
I feel so much better. I was in pretty bad shape the last couple of days.
I can't imagine. And Mr. Linder, you're not getting what Mr. Reedy has, right?
No, that's why I always make sure to stay at least 10 feet away from Brian.
Thank you, Judge. You're welcome. I hear you slightly coughing over there. That's right.
Yeah. I just needed some water.